issue.
So is your argument that if there are witnesses in a case, unless they're subpoenaed, a defendant can tell a witness, don't show up?
Well, if a person has not been subpoenaed, the law allows you to tell them you don't have to show up.
No, not you don't have to show up, but tell them not to show up. That's what the allegation is. He told a witness not to show up. Not that you don't have to show up. I've been a defense attorney and I know that people have told people, hey, you haven't been subpoenaed. You can show up or not show up. If you've been subpoenaed and you don't show up, one or two things are going to happen. Either the state is going to be like, well, whatever, they didn't show up. Either they're going to want to do an attachment.
So I am returning to what I know to be the law. And the law is that we're entitled to two things. For one, all the discovery on the case.
I'm talking about the asset forfeiture.
So the forfeiture by wrongdoing, I do not know when, because I have a case here, the standard is that it has to be wrongful, right? And so the question is it...
Okay, I'll hear it. Court is calling 2022 CR 11013, State of Texas versus Stephen Anthony Estrada. Can I have parties announced for the record for the state? Defense? All right, this is scheduled for jury trial today. Defense, you're asking for a continuance?
I am. Your Honor, as you might have noted, starting about 2 weeks ago, I came by the court, sent court emails, plus emails asking which case to try. The reason for that is I wanted to be prepared to that. As I told the court before, there's no one time, it's either ahead of time or behind time. This particular case, when I say it's an identification case, what I mean is that there's no question that Mr. Estrada's co-defendant is the person in the video. Everyone can tell that. The people that are identifying Mr. Estrada as being a co-defendant are two people. In this particular case, and the reason that on 13 they're trying to go forward, there's a clerk, I believe, says they recognize his eyes. Pretty weak identification. Then there's a stronger identification. The stronger identification is, and I'm sorry, I don't know if it's common law wife, girlfriend, I'm unclear in the status, significant other. You know, you don't like the word baby mama, and I don't think it's baby mama, so I'm not going to say that.
You mean the mother of his child?
Correct. Yes. And I've heard you say that before. So when I say that this is triable, it's triable on identity. Because of that, our defensive, not defensive strategy, I have to explain why I need a continuance. Our defensive strategy essentially is it's not Mr. Estrada. That if his girlfriend comes in and says it's not.
Let's break this down in plain English. This isn't really a robbery case anymore. It's an identity case. The defense is betting everything on one argument. That's not my guy. No fingerprints. A masked suspect. A co-defendant clearly visible. And Estrada allegedly identified only by people who know him personally. That's a risky strategy, but it can work unless something interferes with the witnesses.
The defensive theory is that it's co-defendant's friend, brother-in-law, document. In other words, it's completely avoiding the co-defendant. I don't so much mind it's really obvious. So I prepared for trial. I have in my pocket a thumb drive with all the information that I've completely reviewed. Be prepared to go in front of you today. So two things have happened. The first thing you've already heard about, and I'll take last. And the second one is I'm now told that there's discovery that's being uploaded today. I prepare ahead of time. I am sure that for the state, discovery is not important. It doesn't go to their face. Of course, it goes to Mr. Estrada's right to have an effective defense. I do. I want to look at the discovery. I don't know what it is. And I'm not asking for an inordinate amount of time. Bring me back 2, 3, 4 weeks. I'll be ready. I see you shake your head no.
No, not 2, 3, 4 weeks.
What I'm telling you is that I may be say next week. That's fine. Yeah, I can answer that question. I want to do the right thing the right way. I want to.
This is where defense attorneys start sweating. Discovery uploaded on the day of trial is a procedural nightmare. Even if the state says, we're not going to use it, the defense still has a constitutional right to see it. Why? Because evidence doesn't have to be used by the prosecution to be devastating. It just has to matter to the defense. And here, no one can say for sure what's on that drive yet.
this is in fact the robbery case. And they say it's not the case you're thinking about. He says, don't show up on that murder. Now, I think it's a question whether or not that's wrongful, telling someone not to show up for a different case. That's an issue that I think for next week I'll be better prepared for. The next 2 weeks or whatever you tell me. And I'll await your ruling on that. I want to be prepared for that, and I will be prepared for that as well. The reason I'm asking for time to review the discovery they've uploaded is I know it's not important to them, but I think that a week or whatever you give me is a proper amount of time for us to look at it and judge I'm ready now or not. Absent.
Here's the phrase that just changed the trajectory of this case: forfeiture by wrongdoing. If a defendant intentionally keeps a witness from testifying, even indirectly, the court can allow that witness's prior statements to come in anyway. No cross-examination, no live testimony. That's huge. If the judge finds this applies, the defense loses one of its most powerful protections overnight.
Not allowing me to be effective for Mr. Estrada asked me to look at discovery last minute that very well may change our case. Now, do I blame the state? I don't know enough to blame them, but it's a situation we're in, and that's why I'm asking for the limited amount of time that the court will give.
Judge, I'll address the forfeiture by wrongdoing first. So, Judge, did you talk about another case? My understanding is our investigator did talk that there was another case on the docket. He did mention murder. But in the phone call, which I don't believe the counsel had full opportunity to listen to, they walked away to go talk to the client. Sorry, Danny. He mentions, regardless, I'm going to get 25, don't show. They can prove if you guys show up, they can prove my case. So they know that it's in regards to the cases that we're alleging against. And he repeatedly said, please don't show up. He talks about the consequences if you do show up and present testimony in this case. And they aren't. They were served yesterday. They were served yesterday and given notice. In regards to the second issue, I did tell Mr. Dominic that this was information related to the co-defendant cases, and the fact that it was evidence specifically linking the co-defendant. I believe Mr. Estrada gets brought up in the other cases. I did see that he had a hard drive. I can upload that right now. And
so you're saying this co-defendant is evidence, the co-defendant information that you're uploading is evidence that links Mr. Estrada to this case?
No, it's co-defendant to the case. I don't believe Mr. Estrada is really linked to that evidence. The only evidence that we intended to show was the evidence that's already been uploaded as of today. Again, not including the stuff that I've been uploading right now, but previously. This was more of a, we checked, we wanted to make sure that we had everything in this case because of the co-defendant and because of the federal, the length of the investigation. And so that's why we took the time to go see if there was anything else. I think that Mr. Providence takes a look at that other information. There are several other cases that we looked at with the co-defendant in mind. But the one that we're looking at, I can point out and say this evidence was already uploaded.
All right. So you're saying the evidence was already uploaded?
Yes, ma'am. There was significant evidence that was uploaded in this case and the other case, Mr. Providence.
All right. And the evidence that was uploaded that you say is already uploaded, and you're saying significant. What do you mean by significant?
So it's just both cases have their own e-discovery, links. So it's just each case more and more evidence for whichever case. But when we loop together, the evidence was previously uploaded. That's the case. Yeah, we're not going into new stuff. I'm not going to present any of the evidence that was uploaded later.
So, the evidence that you're saying was uploaded, has he already had access to?
Yes. I don't know if I have or not. What I do know is that I am now being placed in a position where I haven't looked at what they're saying. It isn't whether they're going to present it, it's whether it's material to our defense. And I don't know, Judge, but what I do know is that I've prepared by uploading each and everything that faced to Estrada. And when there's additional information I'm very concerned about going forward. It's the whole reason we signed those discovery acknowledgements, which I cannot sign.
But what he's saying is that it's already been uploaded. And it wasn't just uploaded today, that you already have it.
Well, everything that is on this drive is what has been uploaded in this case, and I am on notice that we're trying today. I believe that evidence might be to another case, might be somewhere else, but I asked them, and I've been in open court to say, I want every piece of information on this case. So if you're intending on bringing information from other cases, that was the reason that I went here today and said, what case are we trying? And I want to be prepared on it. On the wrongful the forfeiture thing, I actually pulled the number of subpoenas that have been done today. I went to the district clerks, and there's only one subpoena requested on file on this case. I have a copy from the court. It's on Emily Rose Fritz, which is none of these individuals, and there's a return on her. So if there has been a subpoena done, I wasn't on notice of it. Of course, what I would have done is I would have discussed with Mr. Estrada, you can't mention the representative, but I can only prepare them for what is in the records. In other words, there is no record of these people either being a subpoena being requested or issued.
So is your argument that if there are witnesses in a case, unless they're subpoenaed, a defendant can tell a witness, don't show up?
Well, if a person has not been subpoenaed, the law allows you to tell them you don't have to show up.
No, not you don't have to show up, but tell them not to show up. That's what the allegation is. He told a witness not to show up. Not that you don't have to show up. I've been a defense attorney, and I know that people have told people, hey, you haven't been subpoenaed, you can show up or not show up. If you've been subpoenaed and you don't show up, one or two things are going to happen. Either the state is going to be like, well, whatever, they didn't show up, or either they're going to want to do an attachment.
So I am returning to what I know to be the law. And the law is that we are entitled to two things. For one, all the discovery on the case.
I'm talking about the asset, the forfeiture.
So the forfeiture by wrongdoing, I do not know why, because I have a case here. The standard is that it has to be wrongful, right? And so the question is it wrongful?
Well, the question is it wrongful to tell somebody that they don't have to, that they don't show up to court? Is that wrongful to tell somebody, do not show up to court? If you show up to court, then I'm looking at 25 years. Is that wrong to do?
I believe that is the question. If that is in fact what it said, which of course is the real problem we have here. So what I don't like to do is I don't like to be at the last minute. They're saying it's in some other discovery. I don't know that.
No. I want to talk about this forfeiture by wrongdoing. That's what I want to talk about.
Yes, ma'am.
So let's figure that out, and then we'll come back to this discovery issue.
Okay.
So that's my question. So basically, and I don't know if this is your argument or not, so are you saying that if there's somebody in custody or not in custody on bond, well, no, let's say they're in custody, that you get out of a trial, all they have to do is, if your trial is on, let's say, hypothetically, February 6th, you can call somebody on February 5th and tell them not to show, and then the defense attorney can say, excuse me, I need more time, I'm just learning about this. And then let's say, hypothetically, that person gets continuance, and their continuance is, let's say it's for March 12th or whatever. I'm just doing a date. And so that defendant knows their court date, their trial is set for March 12th, so they say, you know what? Let me make a phone call. And they make a phone call on March 11th telling somebody not to show up for court, because if you show up for court, things are not going to go well for me. And then the defense attorney can come in and say, hey, I just learned about this last night. So are we going to do a situation, hypothetically, where defendants are allowed to call people the night before their trial, tell them not to show up for trial, and then everybody gets a continuance because I'm just learning that they told somebody not to show up for trial? And these are just questions I have, Mr. Estrada. And these are hypothetical questions. I'm not saying you did that. I don't know. No evidence has been presented of me. But I'm just trying to figure out everybody's legal thoughts on certain situations.
Since I started that a long time ago, thinking I knew everything about the law, I've been dispossessed about that idea.
Oh, me too.
The answer is I don't know. And when I say I don't know, I'm being straightforward and honest with you. I do.
This isn't just a hypothetical. It's a judicial warning shot. The judge is testing a dangerous idea. If defendants can delay trials simply by calling witnesses the night before and telling them not to show up, the entire justice system collapses. Continuances become weapons. Trials become optional. And judges? They shut that door fast. This line of questioning signals something important. The court is already thinking about intent, not excuses.
I do not know the status of the law. I do not know the status of the subpoenas. I don't know this issue. And this issue popped up at the last moment. And it did pop up at the last moment.
Well, Mr. Brabenec, not to interrupt, but I will tell you, I know the law on that unless it's changed. You know why I know the law on that? Because when I was a prosecutor, and Ms. Ferguson will tell you, on family violence cases, you would think you have a witness, they've been subpoenaed, then all of a sudden they don't show up. You check jail calls the night before, whoever the defendant is, has called that person and said, do not show up to court. If you don't show up to court, we're going to have to dismiss the case. And you know what I would do? I would play the DVD in court and say, here's your motion. I'm doing an affidavit. I'm doing a forfeiture.
Well, I didn't change the fact since you've been a prosecutor, because I know you've been a judge at least 4 years, right?
More than that. But I always try to keep up to date on law, so I reviewed it.
So your specific hypothetical was about when you were a prosecutor and you knew the knowledge of some background.
Oh, but here's the thing. I'm telling you that because I have background and forfeiture by wrongdoing, and I always keep up on forfeiture by wrongdoing. And the reason why I do that is because I'm anticipating that usually that happens in family violence cases. So I always check the law every now and then. And then, hey, who knows? Maybe something's changed since yesterday. If it has, I'm willing to be presented with that and keep an open mind on it. I'm always for following the law.
Well, so it has changed since you were a prosecutor, which is where you let me know, and it changed in 2021.
Mm-hmm.
I can't tell you in specific fact because I don't know the brief. But you had already indicated to me off the record that you were not going to grant a continuance on this particular
No, not because you've got new information that your client allegedly called someone from the jail last night on the 5th. At least that's what's in your motion too. On the 5th, I believe, asking somebody not to appear for trial.
Judge, as you know, when I wrote this, I hadn't listened to the audio tape yet. Okay. So it's very difficult for me to make a good legal argument when I've yet to look over things or read things. Which really brings, since you had told me you weren't going to grant a continuance on thing that you are now indicating you're not going to the grounds you should grant a continuance, which is that I don't know. You're telling me there's new discovery that they don't believe is material. I'm telling the court I don't know. I'm also telling the court I prepared. I'm telling the court I downloaded everything. I'm telling the court now with this new information under Michael Morton and under the Texas Supreme Court cases, I believe I'm entitled to time to review. And I'm not asking. I've been a trial lawyer 24 years, which I believe is a little less than you. But I'm not asking for a lot of time. I believe in a week I could be here standing and say, Judge, I'm ready for what? Or Judge, we've got an issue. And if there's an issue, I'll come by on Wednesday, Thursday, Friday as soon as I can. In other words, I'm not going to let it sit out. But at this point in my career, I am unwilling to take the other side telling me that something is not material to my client's case and is not important.
You're coming back tomorrow for trial. That's the time you have. So whatever he needs to see, he needs to see it. If he needs to listen to that the audio from the jail, he needs to listen to the audio from the jail about your request for forfeiture by wrongdoing. You all are here. Listen to it. Coming back to trial for tomorrow.
And that's where we land. No continuance, trial tomorrow, and a defense attorney racing the clock to listen to jail calls that could redefine the case. This isn't about preparation anymore. It's about damage control. So here's the real question for you. Is this a defendant exercising his rights or crossing a line that costs him his defense? Because once forfeiture by wrongdoing is on the table, the rules change fast.